Mr. Chair, members of the committee, we appreciate your efforts to search for solutions to what we all know are pervasive problems. My name is Martin Lynch, and I represent We the People Court Services and the NAACB, which is another court reform organization. I made a copy of a report that was published in 2005 for you to look at the details of, because there's a historical record that shows that the problems that we're dealing with now have been around, and they go back as far as you want to look. And it has to do with checks and balances, or specifically the lack of checks and balances, because absolute power corrupts absolutely. So any individual human being, and that includes judges, lawyers, legislators, governors, everybody, that thinks that they have unlimited power to do whatever it is that they want to do, well then you can expect to have a meeting like this. So I just wanted to point out that what we're dealing with is a problem that goes beyond just family court. It has to do with the violation of separation of powers, where we expect to hire an attorney, and that attorney is going to represent us because we're giving him good money, and a lot of it. And come to find out that the lawyers and the judges are all part of the judicial branch of government, and that's in the Arizona Revised Statutes, Title 32, Chapter 2. If you look, that piece of legislation is no longer around. It's gone. What happened to it was it used to be the regulation of the legal profession by the legislature, along with the other 40 regulated professions that are in Title 32. And so they took it out. And what that did was it allowed the judicial branch of government to usurp the authority that rightfully belongs to this body and to the people through our elected representatives. And so now what you have is lawyers and judges who are all part of the judicial branch of government, and their job is the job of the lawyers is to take the money, and the job of the judge is to help them do it. And then what happens is that later on, these lawyers become judges. The lawyers or the judges retire, go back to practicing and making all the money. And so you can see that it's a revolving door of conflict of interest. And so if you have lawyers that are representing all these different organizations, including giving legal advice to our own legislature, if these people are compromised with a conflict of interest, well then the wheels have come off the entire system. And so the real problem is we come to the legislature, and Representative Keschel can tell you all about it, is we come to the legislature and we say, okay, we're going to put checks and balances back. That's all we need to do. And we have a bill, and it goes to it gets assigned to a committee, and then for some reason or another, or no reason, it's because it's all done in secret, is that bill is not heard because somebody told somebody something in secret, and nobody knows what was told. There's no debate, and so we are in a catch-22, and that is the foundational element of it, is we cannot get our legislators to put a bill out there to restore checks and balances. And
excuse me, Mr. Lynch, do you have a specific bill number that you're talking about?
I have
Oh, all right. I'll just check with my partner here.
and there were bills prior to this, dating back, I'm going to say 7 or 8 years, where we've been down here working these problems. Right. And that's how we've established that we can't get anything done here because the system is compromised.
So can you look like you might be old enough to know. No offense.
Sadly.
No offense.
Sadly, I am,
Sorry.
most likely.
I meant to say you look like you've been around the block a time or two. Never mind.
Yeah.
You've got historical knowledge, tribal knowledge. Do you happen to know when approximately the move in Title 32 away from the legislature into what presumably I would say is probably the bar? Do you know about when that happened?
I don't. I do know that Article 6.1 of the Constitution, which was brought up by April Elliott, because she represents the CJC, came about, I think, in the 80s. And that was a solution that was thought to bring a resolution to the problem that we have, because then judges would have oversight. And she just came in here and told you that they have no authority, no jurisdiction to do anything about the decisions of a judge in any particular piece of litigation. They can work around the edges if the judge is crazy or if he's yelling or screaming or whatever it was that she told you. But when it comes to an appellate action, they have nothing to do with that. And then the other thing that we found out is that in these appellate actions, even if you're quote unquote represented by an attorney, if that attorney does not set up your trial court case properly in order to prevail in the Court of Appeals, well, then when you get to the Court of Appeals, they throw it out and say, oh, I'm sorry, the thing wasn't pled properly at the trial court level. And this goes on over and over again. I can show you examples of it where the Court of Appeals, Arizona State Supreme Court, ruled that because the lawyer didn't do what they're supposed to be doing, now we can't help you. And that was a DCS case. But I mean, the failure mechanism is ubiquitous across all these courts. It's DCS, family court, guardianship, probate. It's everywhere.
Forgive me, but it seems like that would be, I know it makes absolutely no sense. Who would you go to? The court. If you were to challenge the lawyer's authenticity and qualifications, basically defective representation,
Yeah.
where are you going to go? The court?
We go to the state bar.
Yeah.
And then the state bar is going to tell you, and I think one of the ladies here said that out of all the complaints made to the CJC, 485, 3 were valid. So in other words, there's no enforcement going on there. The state bar is the same. Go ahead.
There is a difference between the judicial performance folks and the bar, although it may be a very thin veil between the two. I've had plenty of experience with the bar, and I know exactly what you're talking about. So that's another problem altogether. Okay, you got about a minute to, let's try and wrap this up.
Board of Psychologist Examiners, I have firsthand experience there. I had a psychologist who recommended that I furnish pornography to my teenage son. So I go, that doesn't even sound right.
I'm sorry, time out. Who said that?
A court-appointed psychologist.
Can you reference a case?
My own personal family law case.
Okay, that's close enough to first person.
Yeah.
All right.
Yeah, I mean, I sat in the office and listened to him, and I said, what should we do about this? And he says, well, we should furnish him with acceptable pornography. That's what I listened to. And I go, what is that? And so I do my research. That's how I am. And I find out that that's a criminal act. And so we went to the Board of Psychologist Examiners, and they said, I know none of these people are probably lawyers, but the results that I have documented was that when the judge appoints a psychologist to one of these cases, that person who's been appointed is now sheltered by judicial immunity. They now have the cloak of judicial immunity, and any kind of enforcement of their code of conduct belongs to the judge. They said, we do not have jurisdiction once that court order is issued giving them an appointment to this case. So this Board of Psychologist Examiners can tell you, oh yeah, we can do this, we can do that, we have all these different things we do. Well, none of it applies once there's a court order for a psychologist to become assigned to the case.
Well, with all due respect,
they don't tell you
sir,
that. Go ahead.
I don't give a bloody damn what the court wants to say. When someone is engaged in a criminal act, quasi-judicial immunity does not apply. You're committing a crime. That's like saying a judge who orders the very same thing is exempt because they're a judge.
Correct.
Not in this state.
So we did a criminal referral. We've been to the FBI up on North Black Canyon Highway. And all these law enforcement agencies say, well, you know what? Let the judge handle it. Or they say, we're too busy protecting the country from terrorism. And it's like, wow, okay, well, I think I have terrorism here, but, you know. So in other words, they have prosecutorial discretion. And that's a principle that we want to defend. We don't want to throw it out. However, we're looking for checks and balances here, and they do exist. They are in here. But if your lawyer is not prepared to do what's necessary to, number one, make your trial court case subject to an appeal, and number two, to take the thing to the appellate court. And then the lady just before me said that the judges exert coercive control over the judges. I'm sorry, the judges exert coercive control over the lawyers. And so we're back to Title 32 again, which is blank. Chapter 2, which is blank. And I'll just end on one last note. I keep hearing best interest of the child, best interest of the child. In the Constitution, it says due process and a bunch of other things. It doesn't say anything about that. But there is Supreme Court case law. One is Troxel v. Granville, and the other one is Santosky, where they establish that the primary, most inalienable right that all the people have is to parent their own children. And so that serves our interests. And the problem that we have is that this best interest of the child thing is an artificial construct, and it's subject to the unlimited interpretation by a judge, one person. And when you get into this court of equity, then all of your rights go out the window, and you're subject to what that person invents as what they think they need to be doing. And once you understand that the lawyer's job is to take the money, and the job of the judge is to help them do it. This is the unspoken rule. And so they have this revolving door going back and forth and everything, and it's not something that we haven't seen in a bunch of other areas of our society. And so, so I just thought I'd just throw out that we have looked at, what we need to do to fix this thing, and individual pieces of legislation have been blocked by something secret going on behind the scenes. And there's something called a Department of Government Affairs that's over at 1501 West Jefferson, across the street over there at the Supreme Court building. And those people's job is to come over here and tell you what needs to be put into the statutes. And so until we can rein in these violations of separation of powers coming from across the street over there, then we can come down here and ask you to do stuff forever, and we're probably going to have another meeting like this 5 years from now. Who knows?
Well, Mr. Lynch, actually, we're going to have 3 more of these, and we are going to continue to try and unpeel the onion. Quite frankly, between the last installment and this one, there is a picture that is coming into focus that is actionable by the legislature. Don't think that the folks across the street have more power than you do. I want to assure you, in the words of Supreme Court Justice Ruth Bader Ginsburg, the people are the ultimate legislature. So your testimony here today, the testimony of these folks, is extremely important, because this is not, in my view, a political matter, but politics certainly is in it. Representative, I'm sorry, Fink, you had a question?
Thank you, Mr. Chair, and thank you, Mr. Lynch, for coming. I believe that parental rights, you kind of said what I was going for. I consider it kind of the Ninth Amendment right, because the founders didn't want to, they were concerned that they might not have written down all the different rights, and so they have the Ninth Amendment right. I consider parental rights a Ninth Amendment right. And we've had discussions back and forth. We had a bill in regards to a jury trial, because it is a self-evident truth in regards to, parents and parental rights. And we've heard people say, "Oh, don't know if we want to do a jury trial." Yes. What are your thoughts on that?
Well, the limits of the power of the judge. Let's just talk about all these enormous fees that people are one after another coming up here telling you they're all going bankrupt. bankruptcies and suicides are like another topic. When it comes to veterans and active duty military, there's a Department of Defense report that talks about how family court is one of the causes, root causes for all the suicides you're seeing in the military. So this is something that you can put your finger on.
Mr. Lynch, could you, you've cited this DOD report, could you get that to me, please?
Okay. But I will tell you that the biggest check on the power of these people to take all your money is in the 7th Amendment. It sets forth a dollar limit that the judge has unlimited authority to take your money. And there's a dollar limit in the 7th Amendment over which the judge no longer has that authority unless you do not demand a trial by jury. In other words, I don't need legislation. I can go right here.
Yep.
And it says anything over $20, well, that authority belongs to a jury. That's what it says. Okay, but if you don't have an attorney who's willing to say, well, you know what, $20,000, that sounds a little bit much. Here, we want a jury to decide if you're going to take my children away unless I give $20,000 to your friend over here. And that's when, and this stuff is going on right now, and it's not something you hear about, it's not something that's publicized, but it is in individual cases where these cases just resolve once you take their authority to steal your money away. Well, then why are they messing with you? Why don't we just get rid of you and go on to the next poor person who doesn't know that we can't just arbitrarily take your life savings away from you? So,
And to that point, Mr. Chair, it also, in the Arizona Constitution, there is also the right to a trial by jury as well. So I
Correct.
think that is something that is supposed to be the check on a lot of these abuses.
Mr.
Correct.
Chair, I need one before we let you go, Marty. And you've been at this fight for before I was in the legislature. So thank you for doing that. I need a point of clarification what you talked about. I think you said Title 32, that it just disappeared. What do you mean that there was something on the law books in Arizona that just, I really want you to clearly say.
it's the regulation of Chapter 2 of Title 32. Used to be the regulation of the legal profession as prescribed by our elected representatives through the legislative process. That's what it used to be. But somebody came in here and said, oh, you guys need to get rid of that because we're smarter than anybody else, obviously, because we're judges. If you don't believe me, ask one of them. And they say, well, we'll go ahead and regulate the legal profession because it's so hard and difficult to understand, only we can understand it. And what we understand right now very well is that this whole system, this whole process has been co-opted into a money-stealing operation. That's what it is.